Let's see now. We will call to order the 77th public meeting of the Massachusetts Gaming Commission on September 19th, 2013. And we will begin with approval of the minutes. Commissioner McHugh.
The minutes, Mr. Chairman and colleagues, are in the book. There are two sets of minutes, one for September 4, one for September 6. I move the first of those, the September 4 minutes. I move that they be adopted as contained in the book. If there's any corrections other than typos, I welcome a comment on that.
Second?
Second.
Any discussion about the minutes? All in favor?
Aye.
All opposed? Ayes have it unanimously.
And the September 6 minutes are also in the book. Make the same motion, i.e. that they be approved. If there are any typos, I'll be happy to accept those. Other substance we can talk about, but otherwise I move their admission as printed in the book.
Second?
Second.
All in favor?
Sorry,
Sorry.
were those included in the book?
Yeah.
They
2B? 2A, sorry. No, 2B.
Oop. I thought they were.
Fourth and sixth.
They're combined. Sorry,
combined.
they're combined. They're a single document. So it's the sixth portion of the fourth minutes. I guess I could have done this
In one
together,
motion.
but I didn't.
Should I go out and start over? I'll come back in again. I'd like to call to order the 77th meeting.
We second,
It's really one set of minutes, right?
but
Yeah.
for both dates.
But for both dates, so. All right, so let me
Let's
start
over
over.
again. Okay.
The minutes for the 4th and the 6th are in the book. I move their adoption as printed in unified fashion in the book.
Do we have a second? Any discussion? All in favor say aye.
Aye.
All opposed? Okay. We are on our way. We are going then to Executive Director Day for item number 3, administration.
Good morning, Chairman Crosby, members of the Commission.
Good morning.
I've got a, I'm sorry I missed it yesterday, and again, glad to be back here this morning. I want to go through we've been, as you know, fairly busy around the agency. And I'll start, we've completed renovations to our office space to accommodate our licensing staff in preparation for processing of the slot applications that we anticipate on October 4th. Staff will be moving into the new space next week. And I'll talk a little bit more about the evaluation process later on this morning. Licensing staff have also been very busy identifying licensing database providers that can supply us with a system needed to support our licensing effort by January. Because of the time constraints, the procurement will be restricted to 2 vendors that present implementation strategy with business partners, both being on the state contract. Like all MGC procurements, the response will require detailed information about implementation, will include penalties for late delivery, and will be awarded to the vendor most advantageous to the Commission. And also, with assistance of this Massachusetts IT and ANF, we have identified and will have in place a temporary document management solution to process applications and the evaluation team's work. We have completed work with DCAM to develop and post an RFP for a larger office space location that will eventually accommodate headquarters staff of approximately 100. Our workforce supplier and diversity development director just completed an inaugural meeting of a statewide task force designed to strengthen our efforts to support positive impact by the casinos here in Massachusetts. Might add that we had an excellent turnout and was very appreciative to see the support. We have also selected our human resources manager, who will start on October 7th and immediately begin to help us with hiring, policy evaluation, and classification. Our selection for a CFAO has completed the background, and I'm in the process of identifying a start date. We've also identified our top CIO applicants and are beginning their backgrounds. In addition, we are final stages of hiring accounting and reception staff. Our Investigations and Enforcement Bureau is working to conclude license suitability investigations, and we anticipate the first reports in early October for the casino proposals. This means the Commission will be completing suitability hearings while it evaluates slot applications. We are continuing discussions with the Massachusetts State Police about roles and staffing, and Director Wells will have some additional information later on this morning. Our licensing director also led a team to Ohio to complete a week of gaming enforcement training. We appreciate the Ohio Casino Control's willingness to invite us and allow us to take advantage of their training, and I understand the class was interesting and beneficial to our staff. And with our horse racing staff, have also developed a revised license application and is preparing to receive applications for license in October, for on-site hearings later that month, and back to the Commission for consideration in November. That's the administrative part of my report, and then I would like to talk about the evaluation process. Mr. Chairman, if you, I wouldn't mind if I could go ahead with an update on the evaluation process, and there are three topics that I wanted to discuss with the Commission in particular. One of those are the rating question, and then we can hit that with the rest of the other two.
If you don't mind, I was not satisfied with these and rewrote them another draft last night, which is just being typed up. So if you could just wait for a few minutes and do whatever other topics first and then come back to the ratings.
That will work very well.
Okay.
Those bullets have had numerous revisions, so I think that purpose, what really points out is that the Commission itself had not collectively looked and decided on what the rating should be, and that's the purpose of talking about it here this morning. Let me update the evaluation process briefly. Applications for slot parlor license, of course, are due on October 4th. A team of staff have been meeting with applicants to answer questions they may have about the applications to prepare for their actual submittal. We have developed an evaluation process designed to result in an award of a license in December of this year. I'd like to note that the actual timing of an award of a license will likely be connected to successful determination of surrounding communities. The process will involve 5 evaluation teams, each led by a commissioner. Each team will identify findings and ratings relating to the 5 areas of application, including the general section, or what's unique about the proposal, also referred to as the wow factor, finance, building, and site design, economic development, and mitigation. During the process, commissioners will also hold public input meetings and host community hearings. Reports from the evaluation teams are anticipated the second week of December. In preparation for this process, we have completed procurement of subject matter experts and a project coordinator to manage the process. Jennifer Pink has joined me and is across from me here today. As we move through this discussion, she would be happy to entertain any questions the Commission might have. The Commissioners have selected team members, and we have completed training for those working on the evaluation. In addition, to ensure we are ready to begin the evaluation by the end of next week, each Commissioner will have held training meetings with their evaluation teams. The evaluation process itself will begin October 7th, after applications are submitted, when our licensing staff will review the applications to determine if they are administratively complete and proceed with the process where it's necessary to obtain missing information. Applicants are now invited and will be, if we haven't done it formally, invited to a 90-minute informational presentation to the Commission on October 7th, and we anticipate applications will be forwarded by the licensing group to the evaluation teams on October 14th. As we went through the construction and the development of that process, as is not too unusual, it's a new process, so we've continued to identify questions, particularly those that should be reviewed, need discussion and possible decision with the Commission. There are 3 questions, at least that I have, and we'll see how it goes from there. One is dealing with the rating definition. I'll just take that one last, if that's all right. And the other one is about suitability reports, which I want to talk about briefly and make sure we have the correct understanding. And then the third one is about questions or additional information that we may be willing to accept. So the first one I'll deal with is suitability.
Could I interrupt just for a second? Did I understand you correctly to say that the applications would be forwarded to the 5 teams on the 14th of October?
The 7 days, hopefully I got the right date in my process, but the licenses will get to licensing for review on the 7th. After
Right.
5 days of review, essentially that week of review, then the next Monday they will be forwarded to the evaluation teams.
Okay, so the administrative review is going to take place before they go to the evaluation teams?
Thank you,
week- the
Commissioner
week
McHugh,
after
that
they
is
file.
correct,
Okay,
yes,
Okay,
yes.
great.
Yeah, let me just.
I had a meeting the other day, and I think we misunderstood that, so I want to correct that.
Yeah,
I
so
mean, I
just-
misunderstood that.
I may have done, so say that one more time. So they would go to the evaluation teams on what date?
If I have it right now on my calendar there, it should be October 14th. The Monday, a week from when, October 7th, the next
Yeah,
Monday.
that's the 14th.
14th, good.
Okay, that works.
All right.
And the idea is,
Because my first meeting is on the 18th, I think, right?
Yes, I think our, our assumption when we developed the draft schedule for the training was to slightly different from Mr. Day's, which is to make them available right away for people just to peruse, but that the deep investigation should wait until the administrative review is complete. So it may be mincing words to say they're available on the 4th or 7th versus the 14th. But initially, that was our thought,
and
our assumption.
I think we're, the question is, of course, when licensing, as they review them, we want to make sure that the application material is complete as
Right.
reported, and have at least communicated with the applicants before we forward that on, particularly if there's material deficiencies. So the end result is, I'm using Monday the 14th. We hope that actually that will be a lot sooner, but we'll have to see what the applications look like when they get in.
Okay, because the first meeting of my group is that week, but I think it's the Friday of that week.
I
so
believe
that
it
would-
is.
So that would be okay.
So it's really no later than the 14th, will they be?
That would be
sent?
correct.
Right, okay.
And as always, it's no later, but if.
Right, right.
Yeah, that's the plan. We
Okay.
haven't seen the material yet, so it will be interesting. And I know, I've had discussions with the licensing group. I know they are or will be ready to do their part of the task when we get there. We're
Right.
real confident of that.
Okay.
I have a question on something you mentioned before. We've been getting questions from applicants relative to the submission of these and completion of some of these applications. Will you speak a little bit about pending questions later? Or
Thank you, Commissioner Zuniga. Yes, I mentioned in my initial comments that we've had a team of staff that have been meeting with applicants who wish to take advantage of that to review any questions they might have and talk about what the appropriate direction might be. And we have a list of questions the applicants have asked, and Ombudsman Ziemba will be talking about that later on this morning.
Okay.
So let me talk about suitability. We have also had a lot of discussions that the Commission's suitability decisions and any updates identified by IAB will become part of the record for consideration during this evaluation process. What we really haven't done too much of is make sure that's a collective understanding, and then also discuss where that may take place. And so, leastways, I don't recall we have determined how this will occur. So again, the question here is the suitability decisions that the Commission's reports and decisions the Commission enters, and any updates that may come in between now and then that the IAB feels is important to the process. How will or when will those be considered? Just a suggestion that has come up during the discussion that after the evaluation reports, the suitability reports and any necessary updates become part of the information considered by the Commission. So what that would mean is once the reports that have been provided by the evaluation teams and the Commission takes those into consideration, the Commission would also, as a body, consider the suitability reports and any updates there might be. And I'm checking to see if that.
So that would be outside of the 5-team evaluation process. That would be something that when the evaluation gets rolled up and comes to the Commission for a final discussion, that the suitability reports would be then factored into the process.
That's the recommendation at this point, is that, and because it's the full Commission has decided on the outcome of those suitability reports, it
Right.
seems appropriate that be the commission's purview.
Yeah, that seems right.
Mr. Chairman, one caveat to that. One of the evaluation teams, the financial evaluation teams, there's a question in our application 217 that bears on updates regarding financial suitability and ask the applicants to provide updates. So that would be part of the financial advisory team
Okay.
evaluation, that subset of
Right.
qualifications.
Okay.
Thank you, John.
But
So-
apart from that, we would look again at the evaluations at the stage when we were making the final decision. And the evaluation teams wouldn't participate in that review.
You said evaluations, you mean the suitability?
I mean, the suitability.
Yeah.
Yes, that's
Right,
correct.
right.
I think
Yeah,
that
okay.
is the idea, is
Right.
that
Well, I agree.
there's been a lot of discussion. It's important that those sort of suitability reports be considered
Right.
in the commission's final decision. Just trying to reemphasize where that would occur and how it would occur.
Well, and it's also important, it re-raises a very substantive point that we don't want to get lost in the shuffle, which is there are degrees of suitability. You know, we have decided that there is a minimal standard that people have to get over, but you can be very suitable, you could be barely suitable, and that will ultimately be a consideration in the overall evaluation process, which is the reason why you're reminding us that they will come back into the process.
Thank you, Mr. Chairman. The other question has actually been somewhat, it's been a sort of problematic back and forth, so there may be debate amongst us here at the table as well. But what it is the thought process that involves, we have the formal process up front where the licensing group will go through the applications, they'll identify missing information. We have the 7 and 14 days for non-material, material, non-material, questions that may be revised or identified. The licensing group goes ahead and asks those questions, gets the information back, includes that with the appropriate spot in the applications, forwards it on to the evaluation teams. So that process is pretty clear at this point. And as we move forward, I think it's really important to the process that we emphasize and only allow for really very narrow opportunities for additional information as we move forward in the process in order to ensure fairness of the application and consistency of how they are treated. But it does raise a question as the evaluation teams begin their process. We're not asking our license team to go through the detail of every attachment and those kind of things that are there. The evaluation teams may come up with needed clarification or a missing item that wasn't observed before. At this point, the thought process for what I call non-substantive material would be that those requests would be tracked and by Jennifer Pink and her associates. And at some point, Jennifer and I would review those requests for additional information. The idea of the review is just to make sure that we are not allowing improvement of the application by our response, trying to keep true to the idea that applicants need to make sure they put in a great effort to submit complete information. And then if we were in agreement that those were non-substantive and didn't improve the application, we would request that additional information. What that leaves is there may be substantive questions that the evaluation team has. It's at least in the thought process, it's very difficult, but the original design of the process was if there was such a thing, that the commissioners, those questions would go to the commissioners. The commissioners would decide whether or not to ask those type of questions at the host community agreements. So again, there's debate about, well, just exactly how that occurs, but at least the idea that I put out there is that the chair of the particular evaluation committee, the commissioner, would be in the best position to actually decide which questions come forth at the host community agreement per their evaluation team. Yes?
Did you mention host community agreement and meant to say team meeting?
I should have said host community hearing.
Oh,
Yes,
thank you.
that's
Oh,
correct.
so that the question is whether we first raise those questions at the host community meeting,
Correct.
the statutory hearing.
And, or should they be, excuse me,
Or should
Commissioner
they
McEwen,
be
should it be
asked?
raised at all, or?
Should they be raised at all, or should they be in some fashion raised earlier?
Correct.
Yeah.
Substantive questions, that is.
Substantive, I think non-substantive, we can use unless the commission wants to change that process I talked about. But for those kind of things, it seems we can go ahead and follow through and with that information, being very restrictive on it. But substantive,
And the threshold is something that improves the application. That's a substantive question. The response of which would improve the application. Is that a fair statement?
Well, I think something that would improve, or something that perhaps reviewers on the evaluation team were not entirely convinced of, but seemed to be integral to the applicant's proposal. I'll throw out a fictitious example, perhaps, where an applicant says they're going to deal with a traffic condition by building something that actually would be really great, but the team might think, I don't think you could do that within the time frame between the approvals and permitting and construction, or whatever. But absent that proposal, you might think that's a pretty good one. So and I think that might end up in Commissioner McHugh's category, we might suggest that, or he might be wanting to ask that at the commission meetings in the host community, say, you said that you're going to do this, but we don't think it's credible, so how would you do it? That might be one. I mean, it's where I think the credibility of a response, or the practicality of a response, or the benefit of a response.
It may be hard to set a hard and fast rule in advance without looking at the substance of the question, but it occurs to me, and I think this arose in our meeting the other day, as probably did with other meetings, that if we're going to ask a question, the first question is, do we ask it at all? And if the answer to that is yes, is it the kind of question that requires some thought and study in order for there to be an effective and sensible response? And if the answer to that second question is yes, it seems to me we ought to ask it before the host community, the statutory hearing, because otherwise we're going to catch people off guard with things perhaps that are complicated that they haven't thought about. So I don't know
Are you saying that, so everybody would have, the bidders would have notice so that at the host community meeting, they would respond to these questions?
Well, I don't know, Mr. Chairman, whether I certainly would ask, for those kinds of questions, ask the question before the statutory hearing. Whether we wanted an answer before the statutory hearing so that we could ask any follow-up questions is another piece of this. But I do think advance notice would be important for those kinds. Now, what's the process for going through all that? I don't have the answer for that, but that's the
Isn't it
subject.
incumbent upon them to be very thorough with their answers, to lay out that they've already, started the approval process, that this is the time frame and these are the reasons why they believe they can do it in that time? Isn't it incumbent upon them to do that ahead of time so that we're not left with, Jesus, we don't know, can they do it, can't they do it? I mean, I just wonder if we're giving someone an advantage by going back to them, where someone else may have been very thorough in their response, and it does not leave us that open-ended question.
But suppose, for example, I mean, I think that's a really good point, but suppose, for example, I'll take Jennifer's point. There is a piece of the application that says we're going to put a overpass over Route 93, and everybody looks at it and says, how are you going to do this? This is federal territory. And they didn't put that in there, but in fact, they've already contacted somebody in Washington, and they have an approval in hand. And
If they didn't put it in there.
But why would we reject that might be fatal to the application. Why would we reject it when they have the thing in hand? They've already done the homework, and they've got the thing in hand.
I think we're talking about the threshold question, and I'm torn myself. I think it's sort of like, you should, one approach would be, as Commissioner Cameron is saying, is you are limited to, as they say, the four corners of the document. It is incumbent upon the bidders to make it clear. And if we don't know whether they can get something built in time, that's going to be a demerit in the evaluation process. The alternative approach, however, is you want to provide the flexibility, you want the maximum opportunity for the best proposals to be made. You don't want to have to degrade an evaluation or potentially lose somebody for something that's kind of a technicality or readily explained. So, I mean, I think it's a legitimate, very legitimate difference of opinion about how to approach this, and I'm not 100% sure myself.
I would be in favor of giving ourselves the flexibility to ask that question, however substantive the answer may or may not be, because we may not know until we get those instances in front of us. In addition, I really like the idea of the host community hearing. Prior to that moment, be either prior or at, be the time when that gets fleshed out one way or another, gets represented to us and the public. I think to a great degree, the purpose of the host community hearing may have been designed, I mean, I wasn't there when they designed it, but may have been designed for that very purpose, to flesh out or validate what may be something that needs to be validated at that time. So.
I think there's a balance, as I've kind of thought through this process. I agree with Commissioner Cameron. We're not looking for people to be able to go back and, oh yeah, I forgot to fill that in, so I'll do it now. We are looking for our applicants to make very thorough presentations and thorough applications, provide as much detail as possible. I actually envision questions that might come about is very few in number. But I think giving the applicants a chance to know what those questions might be in advance of the community hearing, or host community hearing, where not only we will have the opportunity to hear the reply, but folks in the host community, whether they're the local officials or the citizenry at large, to hear those responses, I think, to your point, would be a good exercise. I just don't, if the applicants do their job well, I would fully expect that there will be a limited number of follow-up questions.
Well,
But you think we should permit the follow-up questions if necessary?
Yes.
But if we looked at questions that we collectively had and thought about questions that might require some reflection, we could notify them in advance of the hearing that we were going to do that, but use the hearing as the vehicle for getting the answers. That would cut down on the sort of fluid nature of the application. This is really, the application is really it. We're inevitably going to have questions, a lot of questions, at the hearings for the applicant, the host community, the surrounding communities. And those that were important, those that might require some reflection, we could ask in advance.
Well, yeah,
I'm just worried about, then you get into problems with that as well. I'm just worried about having legitimate questions and having questions that can't be answered at the hearing, and so we don't get the benefit of a thoughtful answer.
But you're on a question of assuming we are going to ask questions. What's the process for asking questions? And there's a threshold question, which is, should we be able to ask questions? Which is what I think we have a difference of opinion on.
Well, I mean, that gets pretty fundamental, because what's the host community hearing about if we can't ask questions?
Well, but Commissioner Cameron was suggesting that be the case.
Oh, I didn't. Were you suggesting that we can't ask questions at the host community hearing?
I was suggesting that if the team if the answer isn't comprehensive, if it leaves us with, well, I don't know if they can do that, or it's not clear that they've spoken to anyone in the federal government about this, and it just doesn't seem to, experts tell us, this is really not feasible. Are we giving them a chance? Or someone else's application is very complete, the steps are the timeline, everything, and we're giving them a chance to improve their answer because they weren't complete the first time. I had an issue with that. In listening to Commissioner Stebbins, maybe it makes sense to have a couple of limited questions that that we could take into consideration. And it may be the same thing where you say, well, they should have included that the first time. It just.
But I think we need to come to some kind of a resolution to take that example. If you can't at the hearing say to somebody, we don't understand how you're going to do this. Could you expand on what you've said? And it seems to me that's what the host community hearing is all about.
I'm going to liken it to the notice of adjudicatory hearings that we send out on these suitability reports and suitability hearings. The IEB does send a notice telling them this is specifically what the commission wants to hear about or what we want to hear about. There could be a parallel to in preparation for the host community hearing, something like that. The team, looked at your review, and some of these questions have a level of subjectivity. We want to hear more about A, B, or C, so that we make the most of the host community meeting. I know it's hard when we talk about the tail ends, when something is grossly missing, for example. Sure, that could represent some level of unfairness, say, to the bidders who complete and have a much more robust application. But I think that will be self-evident, and if that was the case, and that if that's discussed in the hearing, then I think the goal has been achieved.
Yeah,
That's interesting.
I'm evolving that way too. I started out kind of leaning towards what you were originally thinking, but I think we're in the business here of maximizing these proposals. We do not want to give somebody an unfair advantage. We don't want to give somebody who has failed to do the job an opportunity to cure it. But we do want an opportunity to really flesh these out and make sure we're getting the best, our own comprehension, our best understanding of what's going on, and the best presentation that these folks can make. And I think if we are careful about it, and we'll pool our questions and think about it, and we'll check the lawyers and make sure we're not, sort of overstepping. But I think I end up agreeing with that. And if there's an issue, if some of us feel like, hey, we shouldn't ask that question. These folks failed. They just dropped the ball. We don't want to give them a chance to cure. We'll discuss that amongst ourselves and work it out.
Or perhaps, I'm sorry to jump ahead, but or perhaps if the team says this is an insufficient rating on this question, then
there's no point.
In trying to hear about it in the host community hearing.
I think to a degree, and I go back to, I think, Commissioner Cameron's concern is I don't want to give somebody an unfair advantage to sweeten the pot in the application when they really should have been doing their homework off the bat. But I think we may be best served by airing these questions, and I like the idea of following the procedures we've taken with our suitability hearings to give the applicant a chance to understand what we're going to ask. But doing this in the confines of a host community hearing may be able enough to send a message to the community as to our transparency, first and foremost, but also to the fact that they can potentially see how we're predisposed to rule on an application, and they'll know why, because they'll hear the response or lack of a response from the applicant to some pretty specific questions.
So we wouldn't be completing our application review until after, I'm trying to think of the timeline there, until after the the hearing, correct?
Right.
And that would be incumbent for all the team members to be at that hearing, I suspect. if
No,
that's what
no.
we're saying.
No.
No?
Not really. I mean, I think that for the most part, it's, by this time, the ball's pretty much in the commission's court. And, the evaluation teams may have generated questions, I don't know. But we will now be, because those are ones that all commissioners attend. These aren't just information gathering. These are all 5 commissioners attend. And we're getting down to the short strokes on our decision-making process.
But the form would be done then. So someone that we didn't think something was reasonable, maybe, or we had real questions about whether it was doable,
Well,
maybe
use
they.
your, like use your
So it may
flyover
have
case.
been just as sufficient, and that work is done, but then we're going to ask a question and receive additional information.
Commissioners, if I might, because from our training, now also we're targeting the host community hearings in the early part of November. The idea has been that the evaluation teams would be involved in generating those questions, if that's the way we went. And then the evaluation teams, for those who could, would actually attend the host community agreements, or I keep saying agreements, host community hearings, because the evaluation team reports really weren't anticipated until toward the end of November. That's when the teams would take in all consideration, the public input, meeting information that we're going to have transcribed, what they've done so far until the host community hearings, information at the host community hearings, and then at that point they would assemble their reports and make it end up with a final report to the commissioners in December. So we were trying to, at least in the original design, trying to make sure that the teams had the full ability to consider all information before they entered their ratings.
So I was mistaken, and I think the way you're saying it makes more sense and deals with your concern. The way, if what I said is wrong, what Rick said is right, and that deals with your issue. So I think it seems like we're pretty well at a consensus that, I think we will understand the difference. I think clarifying the flyover ramp is something which, in my opinion, we've kind of moved to deciding we would want to clarify the flyover ramp. We aren't going to permit somebody to move their annual fee from 15 million to 20 million. And I think we'll be able to tell the difference between sweetening the pot and simply getting a full understanding of what a proposal is really all about.
I would agree.
One of the, and I don't want to delay us too much, but I want to make sure that we're clear on the how. So the evaluation, it seems like to me that the best way for that work, it would really be a process. The evaluation team chairs would need to make a decision on whether that goes to the host community or goes to the question at the host community hearing. It seems like that's about the best way to do it, because the commissioners won't have an opportunity to debate that in public, at least that I could see. And on the other hand, someone needs to be involved to make that kind of a decision that that's an item that should go forward. Unless there's something else, another process out there, but it seems like to me that's about the only way to be consistent about it.
I would agree with that.
I would agree with that. But I also would welcome a written description of all this so that we could take another look at it and make sure that we have the same understanding of what's going to happen.
I agree with that.
That'd
And
be
so,
helpful.
so
Yes.
the bidders do too.
Right.
Yeah, I agree.
And if I heard correctly, part of that was that the if there are substantive questions, those questions be identified by the chairs of the committees. They would be submitted to the applicants in advance.
In advance of the
In
host.
the mechanism, the sort of the pre-hearing conference that Commissioner Zuniga was talking about.
Okay.
Pre-hearing conference?
Pre-hearing style, conference style. I think I got the message.
Pre-hearing
Correspondence,
Yeah.
this is
Okay.
what we would like to hear, or
So I would expect that list of questions or concerns to be a deliverable from each team.
yes.
Right,
Prior to these pre-hearing conferences.
Exactly.
right. It may be, might it not, that there are, because the parties at the host community hearing are the applicant, the host community, the surrounding communities, and the impacted live entertainment venues, it may be that we have to take into account questions that they have in some fashion for each other, so that we really have a pre-hearing conference agenda that takes into account that. I just throw that out. I don't know whether that's so, but it seems to me we should think that through to make sure we understand that as part of the pre-hearing agenda as well.
Well, it occurs to me that as soon as the public side of the applications are made public, the interested parties, would look at that. If we keep our current approach of being open to receipt of public comments during the period of evaluation and prior to the host community hearing, one would hope we would get some of those questions from interested parties, like impacted live entertainment venues.
Fully agree, but those four entities, the other three entities, are going to have a seat at the table. They're going to have the right to be heard at the hearing. Right. And the individuals from whom we get comments, we may use the comments as part of our questioning, are not going to have a seat at the table. And so those surrounding communities and others may have specific questions that it also would be helpful to them to have the applicant think about before the hearing, just as advance notice would be helpful to us. They're in sort of a special category. So we ought to think through a process, it seems to me, where they can let us know of those things so we can put them on that pre-hearing agenda.
Maybe a simple milestone deadline or something like that, X days prior to the hearing.
And I think our schedule was showing that November 7th. We anticipated that we would need to cut off something, some process, a couple weeks ahead of those meetings, so that you could be prepared as well as the applicants. So we'll draft all this up.
I think we've got enough to try a written draft of the procedure. Any other questions on, I think we've got suitability and additional information on applications or application questions. Next topic was the rating definition. And go ahead, Chairman.
I was just going to say that there's a draft coming, but I don't know, it disappeared a minute ago. I'm not sure where it is with copies coming back.
Well, I had one other question that I wanted to ask here that came up again at our meeting the other day, and that is that we were working at our meeting on the assumption that we would follow the evaluation process laid out in the initial training session that really had four components. It had the filling out of an evaluation sheet by each of the evaluators who was going to evaluate that section. In our case, for example, the engineers won't fill out the architecture things. That'll be divided up. But anyway, whoever was going to evaluate a given section would fill out that rating sheet. Then at a meeting, the consensus rating sheet would be filled out for each of the questions. And then at a meeting, that those consensus ratings would be rolled up into a rating for an applicant, and that rating for the applicant with the backup will be forwarded to the commission and form a basis for the commission's ultimate discussion. That was our understanding from the way the training was laid out. There was a suggestion at our meeting that that first step, the creation of ratings by the individual raters, would not be part of the process. That the raters would simply come in and at a meeting of the rating team, evaluation team, verbalize what their ratings or opinions were, and then the group would come to a consensus rating, and that would be the first document in the process. That struck me as troublesome, I guess, particularly since we're not asking the evaluators to make the kind of recommendation that they normally make in a peer review process. And particularly since I thought we'd created this system in order to maximize transparency and the ability to trace back ratings all the way to their source. So I just wanted to put that on the table, and I told the team that I would.
I agree with you. I think that first, I mean, it isn't just the rating, it's the why of the
It's the
rating
why of
too.
the rating,
And I believe our group is anticipating that before we get together, we would circulate everybody's ratings to one another, so that you will have seen why, not only what rating other people assigned, but why, and everybody would have had a chance to think about that before we come to the meeting to try to come to a consensus rating. So I think that's an important step for lots of reasons.
Yeah, and our group had the opposite opinion. Our 4 group members that that step could be problematic in that if someone wasn't understanding the question the same way, it just to have a written record of that early on, or if, look at this group is always following this lead, or we thought it made more sense to, of course, look at it individually, have our own thoughts on it individually, but it really was the group consensus of that rating that really was the documentation. Very similar to how we've done our procurements. You know, it's the same process. There's one rating, and it really is the consensus of the team members.
But the procurement rating follows on the individuals having done a rating, and then you bring in your individual
But
ratings.
that's not part of the documentation that stays with the process.
So you're concerned just about the documentation?
Well, no, I just think it's not just, it just, to us, it made sense to obviously read it, have an idea of where we were going, but that conversation in the meeting about, okay, this is what I see, did you see this differently? And that consensus, and the bullets were the really important pieces, where you get the individual opinions. You know, we thought that was an important piece of the documentation, strong bullets, but an individual, you know, very good versus sufficient, and then you know, and then what is that? Because maybe you had 3 sufficients, and those 3 realized they totally missed something, and then the overall score is going to be a very good. Well, how did that happen? You have 3 insufficients, and you end up with a very good. But that 4th member of the, you know, committee was the one that said, wait a minute, you missed this whole piece. And that's critical. Oh my God, you're right. So that's why we thought scoring it too early could be a problem for that particular reason. And that.
But it sounds like you are saying that from your example, that each individual would go through and do their individual ratings. And then they would come.
In an informal way. It's not a document that gets submitted into the system.
You're not saying they shouldn't do individual ratings. It sounds like you're objecting to the paper trail. Is that
Well,
how I understand that?
It's not just the paper trail, it's the ability to look at the process and say, that makes no sense. You had 3 sufficients and you ended up with a very good. So it's just the idea of the consensus we thought was really important for the documentation, and the bullets were really important. So there may not be a total consensus, but that would be reflected in a bullet. So that's where we thought the process made the most sense and supported what we're trying to do.
Well,
I don't get that.
to balance, I would agree with Commissioner Cameron, actually. The approach on the procurements that we conduct is that up until the time that the procurement management team comes to talk about it and really deliberate about it, all of that documentation is their notes, their
Work
personal
product.
notes. Now the team will produce a work product, and all of that is very important, and it should be as documented as possible and as detailed as possible. But it represents then the work product of the discussions that took into account multiple different points of view, etc. So that was my assumption initially when we started seeing the forums. I can think of scenarios where, given the makeup of these teams, somebody could look back at the documentation and draw the wrong conclusion. I suppose there's a cure for that, more documentation. But I would agree with the general.
I think you've got two different topics going on. One is, what do you want in the record? And the second is, what is the process for decision-making? And it sounds like what the process for decision-making, we all agree. Everybody should have an individual opportunity to discuss, and then then everybody gets together, and I might emphasize the need for consensus a little differently, but fundamentally, you get together and try to come to a consensus. And things like we're clear on that. But I hear the two of you talking about the documentation, that you're concerned, and I think you should speak to this, Catherine, because we've talked about this, about, what is the public records dimension of that first document as we've understood it so far?
I think the first document, in the way I recall our discussion in the training, would be a public record. We've talked a lot about people having notes that are their own, and those would not be. In listening to the conversation, there has to be some mechanism for folks to have their thoughts about each individual question on paper somewhere, because the questions are complicated and they probably have a lot of thoughts and questions as they go through it. So I think one of the purposes of that first document would be to, at a minimum, get those thoughts there. Now, whether folks do or don't fill in the rating that goes there, I think, is a different question. But I do think you need that first piece of paper, and I think you need to be able to get down what that evaluator thinks on that piece of paper. That's going to inform the conversation amongst the larger group. If it's a public record, I think that's okay. That's fine. So.
And the theoretical danger that I gather I'm understanding is somebody doesn't like a decision, they get all the paperwork, they go back to the initial forms, some critical variable, question 7A, looked like it had a 5-to-1 assessment against something, and the one ends up winning, and somebody claims what happened here. Let's assume, for the sake of discussion, that that's a realistic possibility. I think there is a cure for that. There is a protection for that. And I think we've talked about this. You're going to be the note keeper. Your group is going to be the note keeper. If that were to happen, and it could easily, for just exactly the reasons you say, there will be a record of that conversation that will say the group discussed, and because the one was somebody who knew much more about traffic engineering than the other four said, oh yeah, no, I get it, you're right. And that will be in the record if anybody cares to dig that deep.
I just, in addition to that, it seems to me that the same scenario can happen at every level of this process. We can get a rating at that first level in which one of the first level that would be documented under the scenario that the consensus rating was the first piece of paper in the record that had 5 outstandings and one, and somebody else gets the highest rating at the next level. And the highest ratings at the next level, which are the consensus levels for the overall application in each of the categories, can come to us as commissioners, and we can pick one that had a high rating in one area and only an adequate rating and everybody else only had an adequate rating. We could pick one of the adequate rating ones. So the problem permeates the entire process, and the integrity of the process depends on the discussion, the notes, and the little write-ups that go with the bullet points. And it seems to me that transparency is aided by going all the way back.
Well, there's a risk with when an individual knows that all of their individual notes are going to be public.
They are.
There's a risk.
We'll just make sure that you understand what she was saying. The rating sheet would be public. The individual notes specifically would not.
Right.
Point well taken. When an individual knows that the individual rating sheet is going to be public, there could be a scenario where, consciously or not, they err on the safe side of shying away from underrating or overrating, and we get a lot of ratings in the middle. That's a risk, because I've seen it happen. Again, seems like we have a nice, healthy division here, but which is important for our process. But it's one thing that I would know.
Maybe we should request that the evaluators provide bullet points and not a rating, and then the evaluation team actually rates based on all of the input from the evaluators.
Would you say that? I mean, Commissioner McHugh points out that the same exact thing can happen at every stage, including when it gets to the commissioners. You know, you could easily have consensus, 4 out of 5, somebody's outstanding. That sounds like a vote. It's going to be, the winner is going to be whoever gets 4 out of 5 outstandings, and the commissioners get together and say, you know what, the guy who had the 1 was the winner. And, so the only logical consistency is to drop the rating system that we've been talking about for a month now.
I think in order to avoid the scenario that you're talking about, one would have to have established some very clear and consistent criteria on how to evaluate each question. So we would know what is good, we know what is great, we know, and it'd be very numerical, which I think is going to be very, very hard to apply to the questions, particularly in your category, Category 1 and Category 4. 2 and 3, I think, is a little bit easier. There's going to be some subjective analysis of how many jobs are created or revenues created, which is better. But I think it's going to be a lot harder in the subjective categories to have. It would have been impossible to develop that criteria to rate.
Is it? I mean, just in the spirit of compromising, could we legitimately make the first form, maybe change it somewhat, and make that a personal worksheet? That is the personal worksheet of the individual evaluators. What they have on it is up to them, and is not a public record. And that would address, if we could do that legitimately, and then from that point forward, they become public records, but each individual evaluator's notes and individual ratings that they bring to the conversation, which then that conversation becomes public. Could we do that?
Before we answer the legal question, let me just put another issue on the table. I would really like to come to the conversation informed as to what the the individual evaluators have thought. I think that maybe I'm driven by the fact that we have 79 questions of varying degrees of complexity. That's part of it, Frank. But I would really like to come, and I think we all would benefit from coming to the table with the sheets from the other people in hand, so that we could spend some time saying, for example, I didn't see the answer this way. Let me take a look at it again, so I could come to the discussion prepared to discuss and debate in an intelligent fashion. I think it's critically important, particularly given the time that we have to evaluate these applications, to be as informed as we possibly can by the time we get to that conversation. And that means earlier circulation of something. Now, maybe it doesn't have to have the rating on it. I submit that it should have, but maybe it doesn't have to have the rating. But I think that first piece would be an enormously helpful aid, and if it's circulated, it then is a public record. And I don't shrink from that.
I agree. I mean, and in our group, we talked, and I was a little bit concerned about the consensus step, because I fear that at the consensus step, you start to merge, everybody starts to merge towards the lowest common denominator. And you drive out at a consensus step, you drive out innovation, you drive out differentiation. You force people to come to a middle ground. And if you can, happily come to a middle ground, fine. But if you can't, I've said to our group, we're not gonna, the objective here is not to come to a consensus. The objective is to determine whether there is a consensus, and if there is, to document that, and if there isn't, to document that. So, again, I agree with you. I mean, as a commissioner, if I would be interested in seeing those original works, you know, and you know why there wasn't a consensus, and you know what the outlier view was that kept it from getting to a consensus. So it sounds like the issue that we need to think about, maybe we can cop out on this for a few minutes, is to have somebody else, you guys, think a little bit about, you know, really substantively, how vulnerable are we? This is really talking about a litigation mitigation strategy.
Mm-hmm.
How substantively vulnerable are we if we have that first stage of review be a part of the public record, and just have you guys think about it for a while and give us some advice.
For the record, I didn't think that that's the approach, you know, being vulnerable to litigation. But I actually
Why don't you want to do it that way?
Well, because of what I said, somebody could draw the wrong conclusion. You know, I don't know that they'll take civil action or not. I think I like actually the recommendation or the idea that Jennifer points out, making available the bullet points for each question, for each individual evaluator. Passing that around, that's a public record. But the rating for each question is then discussed in public.
And we talked about that with Commissioner Cameron's group, and thought that that sheet that we're debating, where you do rate and have bullets, those bullets should include dissenting opinions. And, you know, or language that says the majority of the group. So that I agree with you, we don't want to have consensus if we don't have consensus. And we want to make sure that opposing thoughts or other thoughts, other ways of viewing the question were recorded, and would be recorded on that final sheet that is the work product of the group for each question.
Yeah, I would be more comfortable, and I know my group would too, if we, you know, certainly we individually look at every question, we put our bullets together, and held off on a rating. I don't think it's necessary at that point.
I wonder if, I would ask two questions. We're talking about the process of arriving at a rating, and to what extent individuals' assessments written are part of the record. And the other question I have is, do we think that every team has to operate in exactly the same way? That your group, Commissioner McHugh, might have more paper in the file, more analysis than someone else's. The other thing I want to point out is I do think that we're recommending that every group identify ahead of time those questions for which we expect the technical consultants, the technical experts, to have produced a report. And I always go back to traffic, because traffic, I think, is number one, a significant issue, and I think the finance. And we're expecting the technical reviewers to review the material and to bring more than just what they thought about it to a meeting, because I believe we should have, if in the record, engineers' reports which substantiate those ratings, because if they are challenged, you don't want to call the engineer and say, well, you know, to court someday, well, why'd you say that? We want to have a legitimate professional engineer or financial consultant's report in the file. Not for every question, because that would be impossible, and there are some that you couldn't write a report on. And so maybe that also goes to some of those, goes to the record that is created.
Well, I think it's a good idea to have a report on some questions. The question is, how many reports do we get, and how much do we, it's happy mediums.
I don't have any problem with
I think it's good
different
to
groups
have
do it,
reports.
but I don't have a problem with different groups doing it slightly differently. You know?
I don't think it necessarily addresses this issue we're getting at, but it might in some ways, because if the approach is Commissioner Cameron's, and there's just one form, but there's been a lot of discussion, which is not recorded. The professional consultants, the HLT in this case, would have produced a report. I'm sorry, McFarland Johnson would have produced some reports that would substantiate the consensus or the evaluation.
You could take your two ideas at the level of the individual questions. There could be questions really that lend themselves really for that rating to come from each of the individual evaluators, where others are really not. You really need an advisor, say, a report to come to the meeting, convince the team about a rating, and that being the end work product.
And I do think these reports actually substantiate the ratings on criteria, not so much questions. If the criteria is job creation, or
So where are we? Somebody summarize where we're
Matter
at.
of fact, I think we might have gotten away from the topic that I thought the commission was coming close. At least as I was listening, it sounded like that the commissioners were leaning toward asking the raters to bring their notes for discussion to the group, but the actual rating would take place during the meeting of the evaluation team, and at that point there would be an entry made, whichever rating it might actually be. That the individual participants would bring their notes. There would be a discussion about the notes and the thoughts about what the raters' thoughts were, and there would be a consensus process. If it was possible, and I think Jennifer's right, if it's not possible, then that can be entered factually. But that's at least what I was understanding.
You said bring the notes, but they would, that admits of the possibility and that they could be circulated in advance so that the team members could look at them before the consensus meeting, before the group meeting.
I think that would be possible, yes.
Yeah.
Yes. Because your notes, that's your thoughts, at least, absent of the rating. And the rating is essentially something that, in effect, is going to be a team rating anyway. So, I think that's the concept that people might be fudge that rating one way or another, not being honest, as well as they're just having a discussion about their thoughts initially. I think that would promote people participating in the thoughts, and then in turn the group can make the rating. That's just, I thought we were getting close. I'm not suggesting that.
That makes sense to me. And the group then has access to one another's thoughts, as well as if there's some expert reports that will help educate and come to a rating based on the expertise needed.
What do you think?
I think that's fine, and I frankly would envision that to be filling out those individual sheets without the score, without the rating score, and circulating that so that that was available to all commissioners. If somewhere up the chain you wanted to go all the way back and figure out how you got to this point, all the commissioners would be able to see that. But what they'd see is the bullet points and not the individual evaluators' ratings. That's how I envision it working out, and I think that would be fine.
I like that structure. We had a conversation about notes in our session, and that those notes not only will help us go back and review, but also give us some idea as to potential conditions to attach to a license at the end of the day.
That's another piece.
I sense
Sounds like a consensus.
fill out the notes absent the rating, and use those notes for discussion and
Right.
circulation. Does that work all right?
Okay, do you want to go to the rating? Do you want to rate, Commissioner?
Okay,
Okay.
thank you.
Do you want to have the rating conversation? Is that next on your list?
Yes, that's
They're now-
last on my list.
Last on your list, okay, good. There was the original, the dated draft is from Pink and Company, and the one that you just got is from mine. Maybe everybody ought to just take a chance to, take a minute to read them and see what you think.
Which one is?
The one with the date on is the most recent from Pink.
Okay.
That's good. And this other one is what I just did yesterday.
You're suggesting we should,
I'm proposing, I wasn't happy with these. I didn't think the structure was parallel, I didn't think it was very articulate, and so last night I rewrote them, but, you know, we can all rewrite them, but,
the tough critics.
That's a tough grade, right?
Well, that's what happens, I think, when you do group writing sometimes.
well, it felt like group writing.
Yeah, I think this is a challenging,
Right.
And I might add, just as
Exercise.
we're reading, that in the process, we had talked about different methodologies, whether it be good, better, best, or Commissioner Stebbins started this out and proposed this format, and that's what we thought the commissioners were moving forward with, was the insufficient, sufficient, very good, and outstanding. So the question remains then is, what do those particular terms mean? And that brings us to the where we are today.
Right. That sort of reminds me, Commissioner Cameron, you talked about, my group plans to meet in advance of anybody doing any rating. To sit there with the questions, talk about the questions, what do they mean, what do the ratings themselves mean, so that we will try to, you know, if somebody will say, well, I don't quite understand this criteria, what does that mean? We'll talk about it.
It'll be helpful.
Yeah, okay.
One of the issues I had, or our group had, was many of our questions are, well, not many, but a number of them are really almost check the box. Yep, they supplied what we asked them to supply, and sufficient was, the way it was originally written, had some negative connotations, so we did not think that was appropriate. And even this rewrite, minimum acceptable, is a little bit of a negative. I kind of like the address the statutory and other criteria in an acceptable manner. There are just no negatives attached to that.
What about if you just added that? I mean, because it's sort of, you could almost do a parenthetical that, or in certain circumstances, meets the statutory requirement. Right.
Right.
Just add that.
Okay, yeah, only because, you know, minimum. Some of our questions, there is no more that could have been provided.
Right, I
So it's not a
understand.
question of a negative, it's just, it meets it. So however we can rephrase that so that there's not a negative attached to sufficient.
I like this formulation a lot. The only question I have is in the outstanding category, and that is compelling experience. I wonder if there's another adjective for compelling that would be clearer.
In the earlier draft, it said strong, and I was trying to come up with another one, so
I
I
know.
wasn't happy either, so.
Yeah.
Just to be clear, too, we're on the chairman's draft.
On the chairman's draft, yeah. Demonstrates,
Considerable experience, relevant experience.
well, those are, compelling is qualitative, and that's what I think we want. It's just not clear what, rather than quantitative. And demonstrates,
Extensive work?
Substantive,
Extensive? Would that work?
extensive. Its meaning is a little more, because it means really that's right on. I mean,
these people really have the background
Right.
to do this.
Not only have they done this, they've done it well.
What about successful experience, like they've shown?
Superior. High level.
Well, you want,
That's getting close to it. Demonstrates high. I wonder if we could supply, think about that, maybe supply an adjective later this morning or something.
If anybody has a thesaurus,
We've got a question mark on it, right?
Can we have
We'll
an
amend-
adjective break?
We can ask we got a couple of journalists over here. We can ask
That's
the
right, yeah, we
journalists.
do, we could.
You guys come
Got
up with
some headline writers
better
here
word
that-
than compelling. All right, so we're going to amend sufficient to accommodate the category where it's just a matter of a check. And we're going to think about the word compelling.
I just want to make sure I'm with you. Did we amend insufficient?
No.
No, that's okay.
Yep.
It was sufficient that we,
Oh, this is on the chairman's draft.
yeah, chairman's
Yeah,
draft,
right.
I'm looking at the chairman's draft.
Right.
So insufficient is, correct. Did you say we amended sufficient?
Yes.
Yeah, to say something like, in appropriate circumstances, address the statutory requirement.
That'd be a
Just-
comma and then after commission. I mean, but
Right.
that would be an add-on.
It'll be an
Yes.
add-on, yeah.
Right.
Okay.
It'd be another way of being sufficient,
Right.
Yes.
which
It's a
is you
different-
provided
it's an
the list of
alternative way.
people you
Yes.
talked to.
Right.
Yes.
Right.
And very good is acceptable, and just the one question on outstanding?
Right.
All right. Other than that, this is the rating we will use for the process.
Okay.
Until somebody changes their mind.
That wouldn't happen.
Should we take a roll call vote on that?
Somebody else gets their knee replaced. Okay, we will then go, so you're done?
Mr. Chairman, I'm done, and Director Wells is next on the agenda.
Okay. Actually, let's just take a real quick break, because
Yeah.
I have a
Great.
couple of things I want to
Great.
You can have my
Convene number 77. Just to think about this, we are, by about noon, we're going to have to stop this meeting. There'll be an executive session during lunch. At 1 o'clock, we're going to want to start the adjudicatory hearing. So it means we've really got only about an hour left for these agenda items. And I guess we definitely want to do yours. We definitely want to do the ombudsman report. Are there other items here that have to get done today?
Mr. Chairman, it would be very helpful if we could talk about some of the policy issues that pertain to the next set of regulations, because we could use the guidance as we move those forward.
Is that, which topic is that?
I think that's under item 5, legal review.
Yeah, okay. All right, so we're going to try to do 4, 5, and 6. Research and problem gambling, if we didn't get to that today, is there anything that we have to do today?
No, there's not. We can get that.
Racing, is there anything we have to do today?
I think we're all right going to October 3rd as the next public meeting. I think I'm okay on that.
Yeah, okay. We can always have another meeting if we have to have it, but anything today is important. And Director Acosta, is there anything you have to have today? Okay. All right, so we're going to try to get items 4, 5, and 6 in the next hour. Okay.
All right, so in the interest of efficiency.
I'm sorry, there was one thing, we skipped item 3B.
Yeah, just real briefly, I included in the packet a draft of the report that's due to the legislature by September 30th. Of particular note is the finance piece that is technically the first time I'm presenting it to this commission. It now includes the results of the fiscal year as trued up until June 30th. And I would entertain any feedback and recommendations or edits at a later time.
Yeah, I haven't had a chance to read it yet, but
I thought the report was great, but the finance and the finance piece in here that you set forward and set forth in section 6, I thought was comprehensible and appropriate. The one question I had was the suggestion that we were going to submit a finance plan for the next year by September 30, and I wondered when the commission was going to take a look at that.
Yeah, that's a very good question. We could request an extension. These finance plans is due to administration and finance, mostly from agencies that have line item appropriations. They're due by September 30th. We don't have a line item appropriation, but we still have the requirement to submit a finance plan like everyone else. I think we can prepare a finance plan, which is what we're doing out of the last budget projection that I did present to this commission a couple of months ago, and it's simply aggregating what we expect to project, what we project to spend in the format that they require it. We could wait until the next commission meeting, October 3rd, to present that, and then forward it to administration and finance by October 4th, really. And I don't think that would be a problem with any of that.
Speaking as a former secretary, nobody's going to care whether we get it there on the 30th.
I don't know if that's comforting or not.
Interesting insight. I would welcome an opportunity to do that, just so that we could tie back into where we are, and I think we're in good shape. The only other comment I had about this is I thought it was terrific. I thought that the executive summary could be expanded a little bit, even if it went into a second page. There's a lot of stuff that has been accomplished this year, and even for those who never get any farther than the executive summary, I thought it would be helpful.
I agree. I thought it was great. I had just some small edits, which I can share with you.
You can
all.
choose forward.
Yeah, I have a couple of edits as well. I can give you those.
Great. Thank you very much for doing that. Okay, Director
Okay,
Wells.
so the first topic is a Region C discussion. During the ongoing scope of licensing process for prospective Region C applicants, some questions have surfaced. I thought it would be appropriate to have some discussion with the commission. You know, as you're aware, this Region C situation is slightly different than the Regions A and B and the slots applications because of two things. One, we've got the tribal issue, which you're all very familiar with. I won't go into detail on that. And secondly, and particularly importantly for this discussion, you know, the commission indicated they were in favor of an opportunity for unsuccessful applicants in Regions A and B and for slots, the slots license, that they could apply in Region C. So given that the deadline is coming up at the end of September, some questions have come up about that and sort of that potential partnering process. One question I got was if a Region C non-gaming operator, so someone that say had just a piece of land, doesn't file the Phase 1 application by September 30th, is it limited to partnering with those applicants that have already filed Phase 1 applications? My impression is that the answer to that is an obvious yes. If nobody's filed, either you or your partner, by the 30th, that you've missed the deadline, in effect. So I just want to confirm that with the commissioner. If there's any question about that, I can read.
Did I say to read it again? I missed it.
If a Region C non-gaming operator, so say someone that owns land, doesn't file an application by the 30th.
Right.
And is that person, if they want to partner with someone in a gaming operation in Region C, are they limited to partnering with those applicants that have already filed Phase 1 applications? That was the question I received.
And they don't file by, nobody files by.
Right. Pretty much. So that's why I think it's sort of a threshold question. If
Right.
if no one's filed by the deadline, whether it be a new applicant that hasn't been in the process or someone that's already filed in Region A or B or a slots applicant and wants to move over.
Then
I think it's an obvious question.
seems to me the deadline hasn't been met, they're
Right.
done.
So then the follow-up pardon me, if you have.
Well, I thought that question implied that an unsuccessful bidder could apply after the 30th.
Right, I think that's the question.
That's the implication.
Right, and I'll get into that sort of scenario a little
Wait minute.
later.
This question, the question you just posed
Yep.
is, nobody has applied. That doesn't include an unsuccessful bidder.
Nobody has applied.
Neither the operator nor the landowner has applied for anything
Right.
before the deadline. Can an operator or a landowner apply after the deadline? And the answer to that question seems to be no. Somebody has to have applied by the
Okay, if
deadline.
that was the question, fine. Right.
Okay.
Yeah.
And then if the question is no, could a Region C non-gaming operator, so say a landowner, file a Phase 1 application and then pay the $400,000 fee and partner with a gaming operator that has not filed a Phase 1 application by September 30th? So the question, I believe, is it's almost like a placeholder. So if someone they want to potentially partner with someone in the gaming industry, but they haven't identified that person as of September 30th, can they file the application really knowing that they
By
have...
December 31st?
By September 30th.
I'm sorry, September 30th.
And then partner with someone later.
Right.
So from my perspective, just from the IEB, I see a big difference between partnering with someone who has been unsuccessful in the other regions but has passed suitability and just slides over, because I don't have to do a lot of work on that investigatory process because most of it's already done. But my concern is if they want to partner with someone that has not been in the process yet, but they've met their deadline, they bring in a new partner after September 30th, can they do that? And so I see two different scenarios, one sort of an easy one for me, but it's a policy question, I think, for the commission, how they want to do that, in the determination of whether something's administratively complete. I know, we've had discussions with Ombudsman Ziemba and General Counsel Blue, about this issue. I'd welcome their comments on how we would approach this. The advantage to a potential, say it's a landowner, to doing that and filing the $400,000 fee is it gets their investigatory process started. So then if they want to partner with someone later, so say someone in Region A or Region B, for some reason, they're unsuccessful in their vote, or they're not selected, they could then partner later, and the person that is now applying new in Region C could have their investigation underway, and they would not have the problem of partnering late in the game and the IEB not having enough time to do their investigation. So that's how I see the question posed.
That scenario is consistent with what we did in the other regions. And by that I mean, of course, we want a good faith application. We understand that there may be additional qualifiers. There were at least 2 applicants that I'm aware of that did not have an operator identified at the time of the application. So I don't think that was a requirement that you have to have an operator, but the application has to be, I don't know if I like the term placeholder. It's a good faith, you're very interested,
It's $400,000, which I think is ipso facto, that's pretty good faith, if you ask me.
Well, but there were, we made a decision early on. We had one that came in, a potential operator that did not have any kind of a complete application, and we denied that.
They didn't have the 400,000.
They didn't have the 400,000.
Agreed, but I don't know that we would have taken just a check without an application either, to be honest. I mean, that's
but
not
no.
our policy.
No, but we need an application, but
But-
somebody you submit an application and you submit $400,000, in my way of thinking, that would be perfectly acceptable. I don't think you should, I think I'm agreeing with Director Wells, I don't think you should be able to bring in a new partner, given how much time there's been, and I don't bringing in a new financial partner who hasn't been pre-approved. That seems to me to be problematic. But if somebody, the landowner applies September 30th and doesn't have an operator and adds an operator between September 30th and the end of December, who's been an unsuccessful operator elsewhere, applicant elsewhere, that would seem to me to be okay.
Well, the only one that would know by December 30th would be slots.
Well, whoever,
But
no, they won't know.
why is December 30th the gating date?
I know.
Isn't that the day the applications are due?
No.
No.
Let's see.
July 20th.
This is Region C, and they're due September 30th, the
No,
application.
I'm sorry, not the application, the final application, phase 2 application.
Right, it's due September 30th for Region C.
No,
No, it's July
In
23rd.
the spring, I'm sorry, in the spring.
But everybody, yeah.
When is it due?
July.
July
July.
23rd.
The final application, phase 2
2014.
application is due July. Okay, so scratch everything I said.
But I think to Karen's point is, we find out there really isn't enough time to interject a new party outside of the parties that are currently in the process. So if I'm an applicant in Region 1, I don't get the license, I'm going to know that sometime in the April timeframe. I may then decide to partner with an applicant in Region C, and that would give you barely a 3-month window. You're helped by the fact that if they've already gone through
Right.
suitability, that
Right.
anybody else would not be able to be thoroughly investigated within that 3-month window.
Right.
But I'm not sure we should limit it. We haven't done that in the past. I think the onus is on the applicant to have it completed in a timely fashion with enough time to investigate everybody by July. For example, if next month that particular applicant partners with an operator who may not be in our process, there would be sufficient time to complete. So I don't know that we should say you can only partner with someone that's already in the process. I think what is important is that they understand these are the timeframes, and the investigation has to be completed, and you need to have a final package. And we've run into that with these present applicants.
Well, you have to have a final package as a practical matter in time to negotiate a host community agreement and have the host community vote
Correct.
and do all that other
But
stuff.
that's
So,
on them.
no, I understand that. I'm agreeing with you. I think,
Yeah, it may be appropriate, just publicly, note to potential applicants, or I can have conversations with them, that they submit it at their own peril and direct them to look at the statutory requirements for suitability. That, I think that, if you come in and, you have a piece of land and no gaming experience and all that, as you can see from the commission's activities to date, that's going to be problematic.
Right.
So,
I want to just pick up on the original point of Commissioner Cameron, which is much like we have done in the other regions. We accepted legitimate, applications. Sometimes some of them did not come with all the partners, whether they were operators or financing or whatever. And eventually, the milestones like having the investigations done with enough time frame prior to the phase 2, the host community agreement process that has to happen sometime in between, really fleshes that out, the need to have a complete application. So my recommendation is to have the same approach. Let's see who shows up. The deadline is September 30th.
okay,
And I think that's obvious.
okay.
Just remind, so the deadline for phase 2 in Region C is what?
July of 2014.
July 23rd is the...
July 23rd.
Phase 2 application.
So the host community agreement would have to be done June, May, mid-May at the latest, which would give if we get our decisions done in mid-April on A and B, that would provide a very, very tight window for unsuccessful bidders in A and B to get involved in C. It's feasible, but tough.
There are also some elections that are
That's
pending
right.
where that might impact.
Where you may lose others. I understand that,
Yeah.
right. And all of the people from the slots will be available.
Yeah.
Okay.
But as a practical matter, we haven't yet had a suitability hearing where there hasn't been an operator. And that comes way before, right?
Our way, I would
Pardon me?
suggest, really didn't partner with an experienced gaming operator.
Our way was going to
They were
They
kind of,
did not have an
yeah,
operator.
all right.
let me see
I
how
thought
that
they were
worked.
going to operate it themselves. but-
The
Our
other,
way didn't have an operator? I thought
Well,
they
they were going to do it themselves.
Fulton was
no, just an investor, was not an operator.
No, they did. They said, Fulton said that they were going to bring somebody in to
Right.
operate.
After
Yeah.
he tried to save it, that was not a,
No, he said that
Initially.
at the hearing.
I know, but that's when they knew they were,
in trouble.
initially, there was no talk, he was only an investor.
But I guess my point is that, and we don't have to decide this now, but my point was that at the hearing, we had an idea of where the operator was going to come from, as opposed to somebody who's, by the time of the suitability hearing, simply says, I have a piece of land, and I'll get back to you.
Right.
So,
Yeah.
I don't think we need a rule. That's just, it would be problematic for
Right.
me as one commissioner, if
Right.
that's the way it showed up.
Just common
Problem.
sense dictates that's not going to work.
Right.
And the ability of those other applicants who are unsuccessful because they didn't put an application in for this region? In other words, we allowed one to move from a region to the slots.
Yeah, that's a little different because they didn't have to identify the
We
slots
didn't
at the
have them
time.
identify in the
Right,
initial.
in the initial submission, but then later we asked for it. And the two that had not identified reserved their rights to switch.
So if someone, say, one of the slots applicants who was unsuccessful says, I'd like to now take my whole project and move it to Region C,
Yes.
that would not be acceptable because they had not put that application in?
No, I think that's acceptable.
Okay, that's what my question.
I
so
think,
that
though, the
would be-
question is, do they have, so for example, if, I'll just say applicant A. Applicant A, for whatever reason, host community agreement, something goes awry, they want to come into Region C. Do they have to file something by the 30th?
Was my
That's the
question to
question.
you.
Okay, so I think that had been one of the questions.
Applicant A from regions A or B?
A, B, or slots? Can
Yeah.
they then, do
We've already-
they have to submit something to be the applicant?
No, we already resolved that question.
So that was the
Yeah.
threshold question.
And I guess from my perspective, as we moved on, the question seems to end up with if there's no operator, does the commission still want to accept the application?
And the answer, I think, is yes.
And it seems like the answer is yes, and it's almost dictated by the time available to complete the investigation
Yeah.
as to whether or not that will work practically or not.
Right.
And my approach during this stage of things is if the applicant doesn't meet its burden and it doesn't produce the information, the burden's on them, and that will reflect in their suitability report. I can't just hold off on doing the investigation or submitting a final report because the applicant has failed to provide the whole information regarding their project. So
There's a huge onus on the applicant if they don't have a partner in mind. They don't think about
They
partnering
could-
with somebody currently in the system. I think they're going to understand that. I
Yeah.
also think it'd be tough for them to even approach a host community saying, I want to negotiate
Right.
a host community. Well, who's your operator?
Right. So there's lots of
Still
difference.
waiting on
But if
that.
they're willing to take that on themselves, then it's worth the risk. If the commission's all right with that we can communicate that and start the process.
Yes.
So unlike the first deadlines, where we had a clear picture of how many applicants, we will not necessarily have that after the 30th because of the ability of present applicants to move into the
Well,
region.
that's interesting, yes. So we could get 1, 2, we could get 0, we could get 1, 2, 3, or, and then see what happens. And
Right.
I'll just keep the commission informed as we move along in the process.
And just for clarification, where an existing, a non-successful applicant moves in after September 30th, they might be adding a land partner that would have not made that September 30th deadline.
Correct.
Could be the
Right.
river.
Which is what we've done in the other regions. We're being consistent.
Okay,
Okay.
let's move along.
And then the other matter, MS State Police staffing, that's just an update for you. I'm in discussions with command staff at the State Police about staffing. As you know, with the statutory requirement that state police have exclusive jurisdiction over enforcement criminal matters relating to the operation of the gaming establishment, there'll be a necessity for state police staffing, and also internally at our bureau. So the legislature has approved a line item for money for a class, which is expected to start in November. And as the class, they would start in November, and then they would have road training probably May through August. So they wouldn't have bodies available till after that. So I'm in discussions with them about buying some slots in the class, similar to what Massport has done and what the Turnpike has done, so that we can have some staffing available for when the slots facility opens and staff internally. We already have 5 members now, and then 2 members are expected to, staff members from the state police are expected to come over to the IEB. And the expectation is that we would need approximately 8 members of the state police for staffing the facility at the slots parlor. There's a little flexibility on that depending where it is, and but generally that's our estimation. So I expect the proposal, which I'll work out with state police and which would come before the commission for your approval, would be for 15 slots in the class. I am concerned because we know there's going to be this class. I don't know when there potentially would be another class, so we're going to have to talk about staffing the resort casino facilities. But we certainly can't buy enough slots in the class now to staff those, so there's going to have to be another solution after time has passed. But my hope is that there'll be another class after this 81st RTT, and that we would be able to partner with the state police in buying some slots for that class as well, or potentially there's the option we would have to run a class on our own if there's no money from the legislature. So we can talk about that at a later time. Just want to put that on your radar screen.
Go ahead.
My concern, and I know that this is something we couldn't avoid because the class is going in when the class is going in, you know, if, for example, this went to an existing facility, they have plans to open within a couple of months.
Right.
Do you know what I'm saying?
Yeah.
So that could be much sooner than when the Class A graduates, B finishes their road duty training. They're-
I mean, my experience with the state police is they are first and foremost committed to public safety, and they are also committed to the successful operation of these casinos. They recognize that you know, especially when they open, they're potentially vulnerable. People are going to come in looking to do all sorts of things and check whether the correct policies and procedures are in place and people are properly trained. So my expectation is they will work with us to make this successful, however that needs to happen.
That's my expectation as well, but I just wanted to make sure we've thought about that.
But you did raise something which I hope you heard. You just said something about if it goes to an existing facility, they expect to open in a couple of months.
Correct.
And the schedule you're talking about is a 9-month, I think, expectation, which we have talked about repeatedly, making sure that we know when the earliest likely opening date is and that we're geared up to do that. But no other department of ours is geared up to open 2 months after the license is awarded, right?
Yes, and that's actually, as far as the 2 months, I have heard no formal information, so we'll see what they actually propose when they submit their applications. But I knew some were talking about the possibility of just putting some slot machines in a temporary fashion. Ultimately, that would have to be something commission would have control over on whether you were to allow that.
I don't even think the statute would permit that.
Yeah, so basically, we've just selected around the 9-month, which is a
Let
short.
me just interrupt, just the interest of time. There's a disconnect here, and I think you need to talk about it, because we've got a lot planning on what we think is a reasonable expectation of the start date. And if that's a fungible date in a material way, we need to think about that. And we haven't had a conversation where we've said we wouldn't open the facility because we aren't ready to do it yet. But that is one possible outcome from this conversation.
And there are some practical misunderstandings too about actually obtaining equipment and how fast that can take place, even if you wanted to open in a short time. So we'll talk about that and see where it goes. Ultimately, though, the commission is in control of when someone opens their facility.
Well, I fully understand that, but as I said, we've never talked about having the commission say, sorry, you're ready to open, but we aren't ready for you yet. No, that would be a big no-no, unless we change our minds. We've never had that conversation. So so anyway, you guys just got to talk about this and
We will.
see where we're at. Okay. All right, is that
All
it?
set?
Thank you.
Thank you.
I think maybe we should do the ombudsman first to make absolutely sure we get that done. And then we'll do what we can on the legal questions side. So, Ombudsman Ziemba.
Great. Mr. Chairman, if you wouldn't mind, I'm going to take things out of order to try to dispense with the quick items so we
Right.
can have a little bit more robust conversation about surrounding communities. In your packet, you have the citizens notice for Milford. Attorney Grossman and I have reviewed the citizens notice. It is consistent with other notices that have been provided, and it meets the regulations that we have on utilizing the exceptions and the citizens notice. So I recommend that you approve the citizens notice.
Do we have a motion?
I move that we approve the citizens' notice as set forth in today's meeting materials, the Milford Citizens Notice.
Second.
All in favor?
Aye.
Opposed? Ayes have unanimously.
Great. The second item, by way of background, we discussed this at our last meeting. We are about to issue a number of answers to questions that have been raised in our pre-application meetings with Category 2 applicants. A copy of that is provided for you. Hopefully we'll issue that by very early next week, perhaps Monday. So to the degree that you have any questions about very specific language in there, please get that to us and we can make any changes. But what I thought I'd use our time for today is to just call out a couple of the matters that rise to the level of either changes or clarifications of policies that we've looked at before. And I'll verbally go through them so we don't have to go through the specific recommended language, which I'll forward to you. But the four issues are on audited financial statements. We talked about this issue at our last meeting, and the general issue was some of these entities do not have audited financial audited financial statements for a good period of time, as they are new entities that have been created for the gaming market. So in the last couple of days, this is question number 2.5 in your packet, which is probably curiously blank to you, but the actual recommendation we worked on with our financial consultants over the last couple of days. We submitted some language to them, and the bottom line of the language is that we recommend that at a minimum the Commission is interested in seeing audited financial statements exhibiting the financial performance of the entity that has developed and operated gaming establishments in other jurisdictions. The applicant should provide a narrative describing the interrelation of the entities for which it is providing financial statements. And then there's also further clarification that contributions and donations, which are not part of audited financial statements, we didn't mean to say that they should be audited, and our outside financial advisors concurred with that recommendation. There is a question on 217 regarding financial suitability. We talked about that a little bit a couple minutes ago, about what are we going to do regarding the first phase of our financial suitability and other suitability determinations, and how is that going to be brought into the Commission's review in the second phase. And specifically, we had a number of questions from applicants asking, where we said, please update your financial suitability. And they asked us, what does that include? For example, if one of the qualifiers got a paper route, should that be added? Because that wasn't in the specific income of what was noted previously. And so what we recommend here is that what we really are getting at is a materiality test. If indeed there is some material information that would be important for the Commission to consider, that all of the applicants are under a burden to provide that financial and other information that is material. And we list, and we will list in the answer, certain things that should be included in a materiality test, such as bankruptcies and litigation and other substantial changes. But in our answer, we put the burden on the applicant that they have to provide all material changes since the qualifiers, since the first round of suitability, and the burden is upon them. The third answer is regarding schematic design, and the good folks over at Pink & Co. discussed the language of that at our last meeting. We discussed that, and there's a recommendation that advanced conceptual design level drawings will be acceptable. The applicant question addresses only the structures of the facility and should not be interpreted to require the same level of design for mechanical, electrical systems, etc., many of which are addressed in other questions within this category related to performance or sustainability goals. The Commission will be looking for design details and dimensions that are relevant to agreements made between the applicant and hosts and surrounding communities. So that recommendation gets at the level of design that we're requiring, but didn't require the full level of schematic design, and that language was worked out with Pink & Co. The final question is, we received numerous questions regarding what we meant by requiring the applicants to tell us what we want for remote regulatory surveillance. A number of applicants asked.
Which question is that?
This is question 464. So the answer in your packet has been revised since our discussions with Michael and Carol and our other consultants on what should be required for remote surveillance. And what they suggested is that what we really meant by that question is that we want to have remote surveillance within the facility, that we are not requiring some sort of remote surveillance at a Commission building, which could raise security concerns in and of itself. Whether or not we would want to do a remote surveillance at some time in the future, you think that would be up to us, but requiring applicants, particularly the Category 2 applicants, to provide that type of a level of detail when it is not, it doesn't exist in the industry, is not what we meant by our question. So they suggest, so this, what we've revised our answer to say is, in providing a general description of the applicant's approach to remote regulatory surveillance, applicants should describe how the Commission and the State Police will have surveillance access at the gaming establishment. The question does not require a description of how the Commission would have access to surveillance data from the Commission's headquarters. So this question doesn't, this answer to this question doesn't in any way try to say that we will never ask for remote surveillance if for some reason that becomes a good idea in the future. It just clarifies when these applicants are filling in their applications in 2 weeks that we're not asking for something that's unprecedented in the industry, to the best that we know.
Surveillance, I take it, excludes data feeds from slot machines, say. Yeah, I mean, that's would be commonly understood as excluding that, because we may want to do that, right? We may
Yes,
wanna have-
that would be different than having a master computer and server facility at headquarters. Two different things.
Surveillance does not preclude data from slots machines.
Yes.
Okay.
I don't think data's ever been considered as part of surveillance.
Okay, I'm
No, I understand your question.
first time there, yeah.
Commissioner?
So,
Well, yeah, and that exists in the industry, remote,
Yes.
data feeds from
Yes.
slot machines.
So the actual language, to the degree any of you have any suggestions or additions, and Director Day had some additions that we'll make over the next couple of days, please let us know, but we thought we'd bring those more policy-oriented questions to you.
I had one on a question that's in my category, question 1-09. I was imagining that this question was asking for much more than this answer. This says just a question of permitting issues, but I was really thinking as an open-ended question. I mean, for example, a bidder might say that the Commonwealth, in order for us to be successful, can't issue any more licenses for the period of our 15-year license, for example, or would need to be open to amending the number of table games and slots or whatever. I'm just making this up, but it was sort of an open-ended question to say, what, if anything, do you need from us to be, the future of internet gaming? I mean, or whatever else. I'm just, so.
I had the same note. It was more open-ended, as to say, how can we, once a license is awarded, help you open your doors faster, get up and running faster, be robust, be successful, not necessarily where we know we're going to assist them with respect to permitting assistance or, the alcohol beverage license, but, it's how we conduct our licensing, prioritizing their employees over, general license applicants, but much more open-ended.
Right.
I had the same understanding. I thought this was a really a big deal question.
Right.
So we'll come up with some substitute language to
Right,
make it
and it's
a
really,
lot more broad.
and it's important that we get that out to people, because if this is the understanding, that's way short of what we're all really thinking.
Okay.
And then I assume that Jill has reviewed 320 and that it is compatible with the stuff that you've been working on so far.
It is.
Yeah, okay.
And
It
Jill
is.
had some other items that she wanted to add in, and I said, absolutely, that'd be a great idea, but can I take the prerogative and use that 20 minutes for the surrounding community discussion, because that specific item that you mentioned might be able to wait until 2 weeks from now? Definition of small business,
Sure.
can I do that?
Yes, I think the timing is, I think we could wait until the next meeting.
Thank you very much.
There are going to be several. We're starting to rush now, and haste makes waste. I have notes on these questions that I would like to have had to discuss, and you've got these legal policy questions that are going to come up, which are big. I think we need to think about whether we need an extraordinary meeting between now and the 3rd to put in stuff that we're not doing full justice to, or maybe on the 3rd we've got time on the 3rd. I'm not sure, but I can feel that I'm not getting an opportunity to talk about some of the things that I think are important. So I would lean towards maybe having an extraordinary meeting next week to catch up on stuff we're giving short shrift right now.
Mr. Chair, is next week
We're a ways, but
Yeah.
sometime, yeah, I mean, whenever. Maybe it doesn't have to be a full, maybe only 3 of us can do it, I don't know, but anyway, I got a feeling,
Concern about Russia.
I got a feeling that by 1 o'clock, we're gonna have some fairly substantial open, or by noon, we're gonna have some pretty substantial open questions, including small business definitions. So maybe we could think about that. Okay.
That directly feeds into my next topic, if that's okay, Mr. Chairman. My next report is a report on the status of surrounding communities. Mr. Chairman, you asked me to do a little bit of a survey to see where we are, and specifically, I wanted to talk about where we are with the Category 2 applicants. I unfortunately report that with 15 days remaining before the October 4th slots deadline, to the best of my knowledge, no surrounding community agreements have been executed. This concerns me greatly. The lack of a Category 1 surrounding community agreements also concerns me greatly. However, 103 days remain between now and the December 31st Category 1 deadline. Therefore, the most immediate concern regarding the lack of agreements is the situation with the Category 2 applications. First, I think it's important to note that there are significant differences in the extent of the likely impacts that will result from Category 2 facility versus a Category 1 facility. For example, E&F filings indicate that a Category 1 facility may generate daily trips of approximately 39,000 trips on a Saturday or 28,500 trips on an average day, compared to approximately 6,500 for a Category 2 facility. For comparison purposes, one applicant notes that a Target store may generate approximately 17,000 trips on an average day and 25,000 on a Saturday. A Category 1 may generate approximately 4,500 trips during a Saturday peak hour. In comparison, a Category 2 facility may generate approximately 600 trips during a Saturday peak hour. A Category 1 facility may employ 3,000 to 4,000 permanent employees, compared to about 400 to 700 employees for a Category 2 facility. A Category 1 facility may necessitate 435,000 gallons of water per day, compared to about 27,000 gallons for a Category 2 facility. By discussing these different impacts, I don't intend to minimize the real concerns the communities have about potential impacts of a Category 2 facility. As the Commission and I've noted on numerous occasions, our review process anticipates that applicants will engage in a robust education and outreach process to inform communities about all of the impacts. Applicants have also been encouraged to have discussions with communities to demonstrate why they believe there may be a lack of impacts, and that is also a very important consideration. With 15 days to go before October 4th, I am very skeptical that applicants for Category 2 will be able to have the robust discussions that we've envisioned. In some cases, important studies on traffic, et cetera, have just become available within the last 10 days or so. In other cases, initial community meetings have not occurred yet and may actually not even occur until after the October 4th deadline. This gives very little time for the level of dialogue that we envisioned. There are numerous reasons why this has occurred. We have discussed that applicants have told us that they first have to get their host approvals in order before they can fully engage in negotiations with surrounding communities. Applicants have focused first and foremost on the most immediate challenges before them in host communities, because those challenges have existential implications on their proposed developments. Also, the rigors of our application process, including background reviews and adjudicatory hearings, in some cases demand tremendous resources by the applicants. While applicants live within these realities and the host communities are direct participants in such demands and therefore can understand them, surrounding communities have needed to wait until applicants were in a position to fully engage with them. Now, with time short remaining under the Category 1 deadline, especially under our Category 2 deadline, communities across the state are feeling the pressure of trying to understand the impacts of these facilities and to understand how, in other cases, the worst fares of their citizens may not actually be demonstrated by the data. So what's facing these communities? Although I'm stressing the 15 days remaining before the Category 2 deadline, both our regulations and the statute contemplate that applicants may not be able to reach an agreement with communities by our RFA 2 deadline. Our regulation specifies that communities and applicants may negotiate for 30 days after our application deadline. If they cannot reach an agreement by then, communities and applicants shall enter into another 20-day arbitration period. In addition to the 30-day negotiation period, our regulations also provide for another 10 days for a community to assent to the designation of a surrounding community status if an applicant designates a community as a surrounding community. Thus, even after our deadline, for applicants and communities working to reach an agreement, there may be 40 days to conclude a negotiated agreement, in addition to the 15 days remaining before our application date. For those that are not designated by applicants as surrounding communities, there are only 30 days of negotiation that follow any designation by the commission of those as surrounding communities after petition to the commission. Now, while there are days that communities may utilize after our application deadline, the use of these days has consequences. In many cases, communities and applicants will be in an increased adversarial process. This may hurt the near-term prospects for facilities to become fully integrated into their regions. Also, it may lead to potential future development delays if the adversarial process continues through the permitting and development process. The lack of surrounding community agreements will hamper our review process, which is predicated upon a deep understanding of the impacts of these facilities and the measures applicants are taking to mitigate those concerns. Further, where full consultations with communities occur at such a late hour, communities may believe that their only recourse would be to come before the commission to protect their communities, perhaps with a greater understanding of both the impacts and, in some cases, the lack of impacts. Communities and applicants would be in a better position to develop a long-term relationship that would be critical to the development of these facilities. During previous discussions, we have asked applicants to opine on our deadlines. They have stated that they are prepared to meet any deadline the commission sets. Host communities have also stated that they would meet our long-standing deadlines, even though compliance is was a very significant challenge. The overwhelming majority of surrounding communities have expressed that they need more time to evaluate facilities, especially when data on impacts is only now becoming more readily available. I could provide further specifics if the commission desires. However, as the landscape changes almost daily, I am not certain what I tell you today has not changed in the prior 24 hours since I may have checked, or in the next 24 hours that may occur. In general, I recommend that the commission discuss whether our current timetable, specifically for the Category 2 applicants, will serve to help the commission achieve its objectives or may hinder the commission from achieving its short and long-term objectives. Now, I certainly note that this process is a competition. Whichever applicant reaches our deadline with the best application by the application date will win the license. Changing a deadline will impact which applicant can reach that deadline in the best position, perhaps in unanticipated ways. However, the challenge before the commission is how to ensure that we have a fair competition while also pursuing other objectives of helping to ensure that negative impacts are known and mitigated. Our objective to ensure that these projects, once approved, will generate jobs and revenues as quickly as possible, and an overarching objective that these facilities will fit within the long-term fabric of the Commonwealth's regions and communities. I know that's a lot to talk about. I can provide other information more specific, but in general, I think that because we have 2 weeks to go before the application deadline, and the last meeting of the commission is the day before the deadline, I thought it was important to bring you the latest and greatest information about the status of these applicants. And unfortunately, it's not in a tremendously, I'm skeptical about the ability of some of these applicants to reach our deadline in the manner that we want them.
There is a lot to digest here, but is there merit to keeping the deadline where it is, and then seeing where everybody is on the surrounding community front as of that deadline, and then talking in a public session, both to the applicants and, if necessary, to others, about the amount of time necessary to do the surrounding community agreements, and, if necessary, adjusting subsequent deadlines to take account of that. I say that because I agree with you that a non-adversary relationship between the developer and the surrounding communities is going to greatly facilitate not only the construction but the operation after the place opens. But also a concern that simply moving back the deadline does not require the kind of concrete presentation that it seems to me would greatly help surrounding communities and us and everybody determine what really was at stake. The current schedule calls for the application to be filed, then those presentations the following Monday. That's a lot of concrete information that I suspect nobody has at the moment, and that would facilitate, potentially at least, the kind of interaction between the applicant and the surrounding communities that would be most fruitful. So that's my immediate reaction.
Yeah, I would agree. I don't think just moving the deadline, there's so many other factors around moving a deadline. And I would agree for those reasons that those meetings in particular will be helpful in moving this process forward.
So what was the net of that, Commissioner?
The net of that was we leave the October 4 deadline for filing the RFA2 in place, that we leave the presentation schedule for October 7 in place, that we then take an assessment as of October 7, again, at the status of the surrounding community agreements, which may well be no different than you've reported today. And that we bring in at the earliest possible opportunity for a public meeting, the applicants and communities, and say, where are you? And what can we do to facilitate your getting together? And then make a judgment as to whether we adjust other deadlines that are driven by regulation at that point. But we could, that's fixable if it's essential. And tailor a new plan if necessary to the realities that we're faced with by then, by the time the application is filed. I just don't think letting this deadline slip back is going to advance anything. And at the same time, I appreciate that trying to cram things down people's throats prematurely. There may be that we have to go to the arbitration. That's not cramming things down people's throats. Everybody gets an opportunity to be there. But if we do that prematurely, it's not the best outcome that we could reach. We may have to do that. But
In the scenario, in keeping to the schedule, do you have an idea of after the presentations on the 7th, when it'd be feasible for us to meet with a community, with an applicant, but I mean, they get a good understanding what the project is on October 7th, 4 or 5 days, a week, to get an understanding as to where we think they are? For that follow-up conversation, do you have an idea or foresee what a timetable would be?
is that
I mean, to you or to John?
Why do we need a meeting to find out where people are at? Don't we know? I mean, that's what John was telling us.
no, but it's more than, we don't need a meeting to find out where they're at. We'll know from John's survey. But if my hypothesis is they're going to be the same place where they are now. Mm-hmm. We've used before, effectively, I think, the forum of a meeting without the formality of decision making, to bring people in and say, it's time for you to reason together. We did that not too long ago, and it worked. And my suggestion would be that we think about doing that and seeing whether or not that could produce the kind of interaction between the applicant and the surrounding communities that would lead to a fruitful agreement before putting them into the involuntary process. I mean, the other alternative is to not change anything, say we're going forward.
And my question is to that, is where do you conceptualize seeing that kind of discussion with the host communities and the applicants following the October 7th presentation?
I agree with all of that. I was actually, as you were going through your remarks, John, I was, in my mind, trying to differentiate the designation of surrounding community, the agreement, reaching of an agreement with a surrounding community, which could come after, obviously, first have to be designated by the applicant. And then the outreach or lack of outreach to those that may not be a surrounding community that we were hoping to, but sounds like there hasn't been much. I think what's critical for us to know that could advance everything you say, Commissioner, is if we leave the deadline in place and we put effectively the burden on the applicant to come before us saying this is who we think is a surrounding community, however many, that would be a very important data point, which is in accordance with everything that you are outlining. It would really sort of force, if you will, the remaining, the ongoing conversations with those communities and the remaining conversations as to whether some are or are not surrounding communities.
I have very mixed feelings about this. We took a lot of criticism for a long time about our schedule because we appreciated, which not very many people did, that this is an incredibly complicated process. This statute, the combination of the background checks and this long-term participatory process was going to take a long time. This is a really complicated, and people didn't really understand it until they got into it. I feel like we are now, actually just like I said about this meeting, I feel like we're trying to cram 10 pounds of sand in an 8-pound bag. And the right way to do it is to take a deep breath and say, we're pushing too hard, let's give them a month, let's give them a whatever. There's a really serious practical consequence of doing that because so many other things that we've got teed up, so many of these deadlines are related. I just think of my own work group. I work so hard to get it scheduled. It'd be starting over again would be a real problem. But I feel very strongly that the prudent thing to do here is to back off. And we've always said we're not going to let the pressure of time, corrupt the process or impede the process. And I think it is now. I think they're going to be running around like crazy people. The surrounding communities that are skeptical about this are going to see this as railroading. It's going to heighten tensions. So, what I would like to find a middle ground, which would be to enable us to keep our schedule going while we gave the bidders and the surrounding communities time to get this done. And I'm not sure that it's doable, but there would be the statute does, as you said, the statute does anticipate the possibility that surrounding communities will not be done, the negotiations will not be done prior to the application coming in. So the statute envisioned that we could start the review process of the applications while surrounding community negotiations are still being negotiated. That was anticipated. So if we were to lengthen that window, if we were to lengthen that 30-day window, setting aside for the moment statutorily how we can do that, if we were to lengthen that 30-day window, go ahead and have the applications come in on the 4th so we can start our evaluation process with a couple of unknown data points. Could we do that in a way that would protect the practical consequences of our schedule right now and relieve the pressure on the surrounding communities and the bidders so they can do this in a non-hyper environment?
That was exactly what I thought I was trying to accomplish.
I was just trying to take credit for your idea.
If we kept the application date online, if we kept the presentation date on the 7th online, and then did as you suggest, the only difference would be that we were shortly after the presentations proactive in reaching out to the applicant and surrounding communities to the extent that they were surrounding community wannabes or surrounding communities by agreement. getting them in here and saying, how much time, where are you, and how much time realistically do you need, and how can we help you get to the goal or impasse in the quickest possible time. That's the only difference between what the theory, that it seems to me functionally would be a helpful middle step. But the rest of it is, yes, push back the deadlines after the application deadline.
Right. I guess a significant difference would be if we were to decide today that we were going to move the surrounding community deadline back. It would today relieve that pressure, and otherwise, if we wait until somewhere between the 7th and the whatever, there'll be this intense period when everybody's running around trying to.
I hear you, but couldn't we, without setting a new deadline, simply say today, as a matter of policy, that we are going to reconsider that deadline in light of the realities, because we want this to be done the right way, and we want it to be done ideally by agreement rather than by arbitration. And we want, as a practical matter, to give communities an opportunity to do that. And we want to see how much time that's going to take. Wouldn't that be a
Yeah, I mean, so your suggestion would be that we say today that we're prepared to let that deadline slip. Move forward as quickly as you possibly can. We'll see where you stand by first week or so of October. But we will now say you're not going to be penalized, you're not going to be forced. So, yes, I think that's a very good modification of what I was saying.
Mr. Chairman?
Mine was a modification of yours.
Well, whatever.
Yeah, but I think.
But then we take the pressure off.
But the one question I would have is whether taking the big picture, looking from, is that, forgetting our practical problems, which are considerable, are we jury-rigging a solution that will solve the problem but leave a dynamic which is suboptimal because we don't want to get all screwed up for a month or two of our schedule? Is it really better to just bite the bullet and give it more time? I mean, I came in here thinking the opposite, but I think we should think very carefully about what's really the right thing to do here for the purity of the long-term process.
Well, I will emphasize the point that Commissioner McHugh made, which is that simply extending the current deadline may not by itself solve or make some of these surrounding communities agreements happen just by itself. So there's a risk in simply just extending the deadline. We may find ourselves to be in early October with still no surrounding community designation, not enough outreach.
Or I mean,
if we simply extend
the October 4th,
October 4th deadline.
Right.
I don't know how big that risk is. I think in hindsight, we did anticipate and hope for all these surrounding community conversations to have happened, but the reality was, as you well pointed out, otherwise. It's
an interesting point. By having deadlines, we have forced people to get their job done, and if the deadlines weren't there, they weren't going to get the job done. Right. And so that's a very good point. Do we, maybe what I was trying to figure out is let's try to take a really high level perspective here. We don't care about the next 90 days, we care about the next 15 years. Let's get this right. Maybe keeping our deadlines in place is a positive too in that sense. So maybe the middle ground is the right way to go, because these folks will need the deadline. I mean, there are surrounding communities that don't want to negotiate, aren't trying in good faith.
No matter what deadline.
There are bidders who have been laggards. So maybe the middle ground is the big picture.
Can I just add a clarifying point, as in, yes, deadlines do put pressure and they motivate people to get things done quicker. But for some of these applicants, I have no doubt that they're moving forward very, very quickly now, but it's because they are past certain things.
I know.
That they just couldn't get by them. And for example, if you have an election forthcoming, once that election is successful, you will be free to do a lot more than you probably did the prior day.
But John, that was, they made a strategic
Understood.
political
Oh, yeah.
decision.
Yep.
It didn't have anything to do with this guy. They said, we don't want to run the risk of having a debate going on with the surrounding community because it might get in the way of our being willing to win the referendum.
Yep,
I mean, that's a
absolutely.
political judgment. So,
Mr. Chairman, could I just make just an addition, is I think where you were going in the end there, if we were to allow the process to actually move forward, there is a section of the process that the Commission has already enacted, which allows a period for a surrounding community to identify itself, that it's a surrounding community, an applicant then to respond to that request, and then a section that has the Commission making a decision. I don't believe, and I believe the legal staff here agree, that there's anything that says the Commission has to make a decision right away. So essentially, you would actually have a realistic, actual view of who thinks their surrounding communities and what the applicants have to say before you have to move over or move any further. And then the Commission would be in a position to take that information and actually decide. I think one thing that's really tough about this area is it is unique. I think you're correct, it's new. I don't think it's really been tried before. And that's always difficult with getting people to take it real seriously and follow the process and move forward. So at least at that point, the Commission will know for sure who thinks their surrounding community and will know for sure what the applicants think.
so do I hear you? Well, can I just ask for clarification? Do I hear you saying that there's two 30-day windows? One 30-day, they can negotiate with themselves, another 30 days to arbitrate. The first 30-day window doesn't start to run until we've determined whether they're a surrounding community or not, or not?
There is two 10-day periods too. The 10 days to say that you are a surrounding community, the 10 days for the applicants to respond, and then the 30-day period, then there's a 10-day period for the Commission to decide technically. But if I understand correctly, it's not required that the Commission make a decision within that period.
The 30-day clock wouldn't run until the commission makes its designation, so you could potentially take a little bit of time to make your designation in the hopes that the communities were having the conversation.
But you could also, at the same time, you could use, those were the deadlines I was thinking of extending. You could also proactively bring people in to ask them before you started that 30-day clock running, how much time they think it's really realistically going to take for them to come to an agreement, and why. And there may be things that we could facilitate doing, or help them facilitate doing, that would shorten that time, and use that as an opportunity. That process of designation is really an opportunity to talk with the applicant and the surrounding communities, and make some judgments based on the reality of the application that was filed and the explanation of it.
Right.
Actually, you have the issue before you with some facts in order to address it at that point.
Facts are, yeah.
Always.
Wonderful things.
Just one other thing to think about. If we do this, which I think is a evolving, reasonable plan, is our evaluation process degraded in any way by having a number of open surrounding agreements? Does it change the dynamic of the evaluation? Does it change the surrounding community's negotiations because the proposals are already in? They've seen the 90-minute presentation. Are we setting any dynamic in play that's bad? Do you see it? No.
No, I see your point where applicants that have met the deadline are in a different place than applicants that have not met the deadline and getting surrounding community agreements. And there's different data sources. I just don't know how it goes.
Yeah, they're actually in a better place. I mean, because, we will look favorably, obviously, on those people who got their surrounding community agreements done on time. We've said all along that we will take into consideration the nature of the relationships with the surrounding community. So that this hopefully people won't be interpreted as a reason to slack off. We have been saying, talk to the surrounding communities, get this done. So it will accrue to the benefit of people who get it done on time.
And Mr. Chairman, and there's a protection for the surrounding communities anyway, because the commission can't make an award until there's an agreement as well.
Right.
So it seems that it really would put the commission in a better position than it is at this point, with just trying to anticipate what might be out there.
Right.
Well, I thought the statute said we couldn't consider it, but I interpret that to be a formal consideration. But your question does raise something, and that is, if the surrounding communities reached an agreement, the application might be altered in some. In other words, negotiations between the applicant and the surrounding community might yield a slightly different application than the one we get without those conversations. I don't think that's a big enough risk to change this middle ground that we've been talking about.
But I feel like, I think there is some distortion in the process that'll take place.
Right.
This throws in an unknown that wasn't anticipated.
Right.
We kind of don't know. In a perfect world, I personally think in a perfect world, we ought to give it a month. But I think the consequences of giving it a month are so great for so many other players in the process, including the construction workers who are trying to get their jobs, that is a greater loss than whatever the peculiarity to the dynamic is that will be caused by this. So let me just make sure I'm absolutely clear on one thing. The application comes in on October 4th. Under the statute, the process relative to surrounding communities is exactly what?
The surrounding community has 10 days to petition the commission.
Yeah.
And then the applicant has 10 days to respond.
And then there is no time frame during which we have to respond?
Not that I see. Not
No.
that I see. You've estimated that we would respond within 10 days.
Okay, so that's 30 days, so we're now to November 4th. Then there's 30 days for them to negotiate. That's December 4th. So there's already 60 days without us doing a thing that's available in the process for the negotiations to continue.
Well,
And then there's the 30 days for arbitration, which takes us to January 4th, which is our deadline date, basically. So, and so what we're saying is, we're going to stick with October 4th. We're going to urge host bidders to negotiate in good faith and aggressively as quickly as they can and try to get their surrounding community agreements done. We're saying to surrounding communities in particular that in our statute, there is a 60-day period of time, not 30, 60-day period of time, from October 4th to December 4th, during which they can continue to negotiate with the bidders, pre-arbitration process. And it's up to us, we have the flexibility to make that window even longer by not deciding after the first 10 days as to whether a community is a surrounding community or not.
That's all accurate, except most of that's in our regulations.
It's in our-
Not the statute?
Yeah.
It is.
Oh, I
It's
thought.
in the
Not the
regulations.
So we
It's in the
have more
regulations.
control over it.
Oh, okay, oh, even more so, okay. All right, so that's much, there's much more flexibility in there than I quite realized. I was thinking there was only a 30-day window, but there's at least a 60-day window and really much more than that. Okay.
I'm not trying to complicate things, but obviously, we are going to be putting communities in a position where they may not have a tremendous amount of information to file within 10 days of the application. And that starts the adversarial process. I understand the point that will things change between now and the application date? Maybe not. I understand that there'll be a tremendous store of information that will be included within the application, and that may enlighten communities on whether or not they are a surrounding community or not. But I do think that this ticking clock of this 10 days after the application deadline forces the adversarial process, and it doesn't necessarily mean that applicants will have been any more forthcoming with information outside of the fact that some of that information is included in their application, but applicant communities may not be in the position to evaluate that information. Now,
But
the obvious-
there's more than the application information. There's a presentation on
Well,
the
that
site.
is exactly right. So you have the application information, which will now be available to communities which it had not been before. And one thing I'll do note, Commissioner McHugh, obviously are involuntary disbursements, but there's no timetable on involuntary disbursements. So to the degree that a community is still aggrieved by the lack of information, even after the application deadline, even where it's not a surrounding community, potentially you could file for an involuntary disbursement.
And I agree, but that's the part that I think where we need to be proactive before that first 10-day clock starts running. That this process hasn't worked in the past. Cramming it now and putting pressure on people to make it work isn't going to make it work now, without, I think, some commission handholding. So my idea was that schedule is there to play itself out, but that before we start that first 10-day clock clicking, we bring the applicants in, we bring surrounding obvious and wannabe surrounding communities in, we sit everybody down and talk to them. Where are you in the negotiations? What information, now that you've seen the application and the presentation, do you need? How much time are you going to need to do it? Why are you going to need that much time? And try to adjust this in the processing of those regulatory time limits in light of the actual needs of the communities, so that we can shepherd this thing through in a way that facilitates the greatest likelihood of a resolution. So if the pressure release would be to say that we are perfectly prepared to extend that first 10-day deadline until we have that meeting shortly after the presentations, and then we'll take it from there.
I agree with all of that, and I would note some of the remarks that you made, John, also include very important data points for surrounding communities. At this point, I think the ENF that is likely going to come with these applications will include a lot of relevant information. I particularly like your comparison with a Target store. That should provide the public a lot of information. If there's comparable impacts, maybe they'll be able to relate to some of that even from day one. But ultimately, I agree with Commissioner McHugh.
So what I would recommend is between now and October 3rd, is that perhaps Catherine and myself and Executive Director Day could come up with a series of recommendations of how this could work. If indeed there is any regulatory relief that we would need, for example, the 10-day petition before the Commission for Surrounding Community Status, if that would need to be changed to give the Commission more flexibility, we can come to the Commission with a package on October 3rd. Council Blue, does that make any sense?
And we could talk
We could
about it
do that.
before that. I think we're running up against some other deadlines, and we've got some other important business to do. I think we have a pretty clear understanding of what we would like to do here. We can think about this a little bit and make sure that we haven't stumbled across something.
Yeah.
And then I think we probably ought to publish it. But let's move, if you're okay, let's move on with this sort of presumed consensus. We're not going to be able, obviously, to do the legal questions, Catherine. There is important ones there. We need to talk about that. I think that goes to the question of whether we're going to need additional meeting or whether we can wait till the 3rd. But we are going to, during our lunch break, there's going to be an executive session. The Commission will now go into executive session pursuant to MGL 38, Section 21A5, 21A7, and MGL Chapter 66 and MGL Chapter 4, Section 7, 26F. The Commission will reconvene in open session at the end of the executive session, which we think will be around, what?
It's already
Yeah.
1:20 now, 12:20.
Yeah.
I think we needed at least an hour.
Yeah, so probably 1:30. Do I have a motion to go into executive session?
So moved.
Second?
Second.
I'd like to take a roll call vote of the Commission to go into executive session. Commissioner McHugh?
Aye.
Commissioner Cameron.
Aye.
Commissioner Stebbins.
Aye.
Commissioner Sulica.
Aye.
And the chair votes aye. Thank you. The commission is now in executive session. We'll have to empty this room, although the executive session will actually be technically over there.